Good morning, everyone. Welcome to the First District Court of Appeals. Good morning, Mr. Donovan and Ms. Gieske.
Good morning.
Ms. Gieske, how much time would you like for rebuttal this morning?
I'd like to reserve 3 minutes, Judge.
Okay, thank you. So we have several cases on the docket. The first one being argued today is State versus Thompson. Ms. Gieske, you may proceed when you're ready.
Thank you. May it please the court, Mr. Donovan. The facts of this case implicate Fourth Amendment concerns, which unravel the case and require reversal. To begin, Officer Smith did not possess reasonably articulable suspicion that we believe was sufficient to extend the stop. Now, to be clear, we're not challenging the initial stop. He had testified that he stopped them for a stop sign violation and window tint, and we are not challenging that. And we concede that officers don't need a reasonable suspicion to ask a detained driver for their identifying information. This applies to passengers too, and that they may ask the driver and passenger about matters that are unrelated to the stop. But here's the important part: so long as those questions do not measurably extend the duration of the stop, and it is.
So your argument, just to make sure I understand, is focused on what is it, the 6 minutes until the dog, the canine unit got there.
It's actually, so in Judge, in reviewing the body cam footage again, I believe it is actually going to be longer than that, because so Officer Smith testified that he called for backup due to Mr. Thompson's movements toward the center console. Okay. When the body cam footage turns on, you can see two other officers already standing behind the Hyundai. So at that point, he had to have already gone up and stopped them and not turned his body cam on yet. So we actually don't know how long the stop had been going on already by then. At the 3 minute and 28 mark on his footage is when he calls for the drug dog and starts writing the ticket. But again, we don't know how long they had already been there. And Officer Smith did testify at the suppression hearing that it is their own departmental policy to get a canine on scene within 20 minutes. Even if you look at the footage that was presented, the canine presented on scene at 23 minutes and 50 seconds. And that's not considering how much longer they had already been sitting there before he turned his body cam on. So we really can't distill it down to a 6 minute mark. That was just the extra upon the extra time that they were sitting there. So it's our position.
Is that not what we look at? I mean, we look at, he wrote the ticket and then the extension beyond the writing of the ticket, right?
Well, to an extent. So the ticket he took, got in the cruiser, around the 3 minute mark in the video and handed them over the ticket and told them to sit tight around the 18 minute mark. So I don't know if 15 minutes to write a ticket is reasonable, even they gave them the legit names and social security numbers right away. So, there might have been a little taking of the time writing the ticket as well. But again, even when you consider he right away wanted to, call the drug dog. He knew right away why he was extending the stop. And when you look at the entire time, like I said, the body cam alone is almost 24 minutes plus whatever time they had already been sitting there. And that would be where we say that the stop becomes unreasonable.
Well, I guess I'm just trying to understand, though, like, what is the rule of law that you're advocating here? Because, I mean, I worry about saying like, oh, well, this officer didn't write the ticket fast enough. Or there was a couple minute delay after writing the ticket and when they were summoned out of the car. So I'm having to understand, like, what is the exact rule of law you would want us to implement here?
It's not even a rule. It's not even a new rule of law. It's just applying the law as it exists, that the officers, even if they've got a suspicion, and I think there was some point of testimony that he had contact once before with my client. And, even if there is a suspicion initially, the stop cannot be extended and you cannot make people sit there and wait for as long as you want. And, even that's even evident in Officer Bricker's concerns when he says how far he is. He says, I'm 17 minutes away. You can hear the concern in his voice. And the reason he brought that up is because he was not close, and that, that's a concern. You can't just keep sitting there So it's really not new law. It's just applying the law as it exists, that the stop at some point the duration becomes too extensive. And we would say the facts of this case do satisfy that standard. Even if,
can I ask you, what do we do with the fact that neither person in the vehicle could even drive?
I thought that was actually the weakest argument, Judge, because, you know, it doesn't appear that the car's not in the middle of the road. You know, once he handed her the ticket, they were free to walk away, even if the car was illegally parked. You can see when Officer Smith gets out of his cruiser to hand the ticket over, he greets the woman who's the licensed driver, who's their friend. She happened to be coming over to the apartment anyway. You can hear Miss Stevens say, because she was going to bring her money, she was already there. And they were right by where they lived anyway, so they could have very well just walked away.
So the officer should have handed them the ticket and said, okay, I know you can't drive this car, but you can leave. Bye.
Yes.
Okay.
He could possibly have waited. He said, sit tight for a couple more minutes and you'll be on your way, which was, you know, not true, but it wasn't even a couple more minutes. It was still another 18 minutes to 23 from that. And again, we still don't know how long they were sitting there to begin with. But even if you do not want to overturn the stop, that does not end the analysis in this case. You know, I don't want to argue the Jackie Jackson issue, but I just wanted to get that preserved in case. I don't know if Jackie Jackson will directly affect this case. It depends upon if the defendant is successful, how the Ohio Supreme Court words that opinion. So I just wanted to put it on your radar.
Counsel, can we go back to the extending the stop?
Yes.
So the state cited 4 factors. The furtive movements, the chattiness during the stop, the tendency to lean forward over the center console, and the location of the high crime area. So taken by themselves, they probably wouldn't support a stop. But are you arguing that together those are not sufficient?
The only factor I think is strong in favor of the state are furtive movements, which we don't see on the body cam. I looked very closely at that when I rewatched it again yesterday, and any kind of nervousness, I did not think they acted out of character. Out of, you know, everyone's nervous getting pulled over. It didn't seem out of the ordinary. I don't know if the high crime area stuff. I think that's mostly what was redacted at the motion to suppress hearing. So. If that came out later at the trial itself, that can't be considered as a factor here for assignment of error number 1 anyway. And then the leaning could have been another indicator with the furtive movements. But again, the body cam wasn't on for furtive movements. We don't see them, and they didn't seem to be engaging in any. I watched very closely and I didn't see anything like that.
Yeah, I mean, it seems like he's playing with his phone,
right,
from what you can see on the video.
Right.
I think what the officer testified to, if I'm not mistaken, is that he could see as he approached the car through the mirror, he could see the defendant, you know, doing something. And then obviously there's a difference in angle between the officer's eyes and
right.
the body cam video. So.
There is, and that gets hard, and that's where I would point the court toward. You know, it's kind of strange. He says he tells them, I can't see inside your car at all, but then he says he could see that at this this perfect angle on the side view mirror. It's just kind of not believable. But like I said, even if you don't want to apply the facts to the law in Mr. Thompson's favor, there's still the potential for Jackie Jackson to affect this case, but also the plain view exception not applying because of the 3 prongs that are not. We would argue that prongs 2 and 3 of the plain view test are not met. So the first prong, whether the officer violated the 4th Amendment in arriving at the place they were at to view that evidence, is what will be affected or not by Jackie Jackson. So putting that one aside, we still would say that the 2nd and 3rd prongs are not met. Second prong is discovery of the evidence must have been inadvertent. And here, the discovery was done pursuant to what we would say is an intentional search. It was not at all inadvertent. And the case law of the Ohio Supreme Court, and I will butcher the name, State versus Halk-Zizak, that we cited in our brief, says that when the police know in advance what they'll find in plain view and intend to seize, it has to be in a warrant. You cannot avail yourself of the plain view exception. And the way that Officer Smith was talking the whole time suggested that was an intentional search. He did suspect and was right about what he would find. So we would argue that that prong is not met. And then prong 3 is that the incriminating nature of the item seized must have been immediately apparent. And if you look at the, it is I think Officer Bricker says, what's that piece of plastic? What's that plastic? It's tiny, tiny. One thing you can't argue with this case is the amounts are tiny. So it could have been anything. So we would say that that was not immediately apparent. Even if you don't want to reverse the case on that, though, there are evidentiary, and I think these are actually the most interesting issues in this case are the evidentiary issues. And the two are, I think I want to talk about the second because it implicates Hall and it's just so academically interesting, is I think it's an issue of first impression in the state of Ohio, the interplay between the drug lab report statute and Crim Rule 16K. And there was an objection below that no expert report was provided for Melissa Sterling, who was the drug analyst that was brought in. And Mr. Thompson did assert his rights under the statute to have the drug analyst brought in. But the affidavit attached to this report is what is required by the statute. The affidavit has what the statute requires, which is their education and where they work, and that's it. And we would argue that under the plain language of Crim Rule 16K, that this does not provide actually either of the Crim Rule 16K, not fully enough requirements. So you have
wait, what are you saying was missing?
So under 16K that you need two prongs. The one is the expert's findings, analysis, conclusions, or opinion. And then the second is qualifications. So qualifications, she said her education only. The problem that arises is that when you have this this affidavit, and then at trial, she adds a bunch of material that wasn't in the affidavit that arguably does speak to qualifications and opinions. So she adds she describes how the lab is accredited by these two organizations, that she's required to, she has this specialized training that is part of this accreditation process. She has annual proficiency tests. When funds are available, she attends this forensic conference. She noted that she had been qualified as an expert 5 to 10 times in Hamilton County, and that even then it gets to the part where she talks about what she did in this case. And she used this gas chromatograph spectrometer to analyze the substances. She talks about the steps she takes to reduce contamination.
And Ms. Gieseke, you are at your time if you'd select to reserve 3 minutes.
I'll just take a few minutes to finish up. So our argument is that this additional information that came out at trial, these are the things that need to be in the expert report on the front end so that defense counsel can make an informed decision to either consult their own expert or to do research in these areas so they can effectively cross-examine the expert.
Did trial counsel object to, I know trial counsel objected to her being an expert, but did she object to her testimony, Ms. Sterling's testimony?
She objected on the record that that Ms. Sterling should not have been able to testify as an expert because no report was given. And because that is how 16K operates, the remedy is that the expert shall be prevented from, in fact, the staff note to 16K, which I have out for another case, hold on, says that failure to comply with the rule precludes the expert from testifying at trial. So that is the end result of not getting the report. So she did preserve that argument, yes. And I'll reserve the remainder of my time if there's no further questions.
Thank you. Mr. Donovan?
Sorry, it took me a moment to find the unmute button. And I guess the easiest thing to do is to just start where we just left off with 16K, and then I'll move backwards towards the motion to suppress. Judge Bach, I think you're correct that the objection was just to her being qualified as an expert. There was no objection to any of the testimony, and the issues as to her training and the gas chromatograph and the accreditation of the lab and all of that, none of that was raised below. None of that was even raised in either the initial brief or in the reply brief. And this is being raised for the first time here at argument. So I'm at a bit of a disadvantage.
So are you saying that there was no objection that her testimony exceeded the scope of whatever the report was?
There has been no, yes, it appears from, and in fact, I believe at transcript page 324, I believe it is, the attorney says that I certainly expected this testimony. I expected her to testify as to the drug substances and that she analyzed them and that was all expected. And if the purpose of 16K is to prevent ambush, if the report that is given provides ample notice as to what is going to be testified to, and that's what the prosecutor argued below, the objection appears to be that there wasn't an additional summary of what the testimony would be. And what I would point to is that 16K offers in the alternative that the report must contain this or that, testimony or analysis or findings or opinion. And that there's, significant case law that says that, medical records can satisfy 16K, that it's not one specific form. And I don't believe this court or any other court in Ohio has ever said, it has to be this one specific form and it has to contain these different things. The purpose of the rule is to prevent surprise.
So if the report just said, it's my opinion that the substances at issue were, cocaine and that they weighed X amount of grams, but there's no discussion of the methodology or how the expert arrived at that conclusion, that's sufficient under 16K.
I believe that the report as it is constituted, which speaks to analysis, speaks to their CV and everything, has always been sufficient, that this would be a novel interpretation of 16K and a complete reversal. That, this isn't a case like in Davis, wherein, I believe it was Mr. Topmiller testified beyond the report that the drugs in question would have had an impairing effect. There was no opinion that was offered in excess of what was presented in the report, that the opinions were there. If there was,
well, and I guess that's my question that I'm trying to push you on a little bit is an expert saying, here's my methodology and here's how I arrived at this conclusion? Is that beyond the expert report when the expert report only says, here's the conclusion?
I believe that if that were going to truly be an issue, that needed to have been challenged in the trial court, that if they were going to challenge her qualifications, the accreditation of the agency and different things like that, that had to have been an issue that would have been litigated below. And it wasn't.
As a motion in limine or something.
As a motion in limine. Or
like a Daubert type of thing.
Yes, ma'am. Yes, ma'am. Absolutely. When it was raised in some fashion, it can't be raised for these arguments can't be raised for the first time at oral argument. And the argument about the accreditation and about the gas chromatograph and the equipment used and those things, this is the very first time that is being raised in any way, shape, or form. And that's not sufficient. I mean, that, if the court wants to entertain that, then I can try and better prepare for responding to that argument. But that argument has never been raised until this moment. What we have is that the report was given and that the defense counsel at trial said they were not surprised by the testimony that was given. They just didn't think she should be qualified as an expert. She can testify about these things, but she shouldn't be qualified as an expert.
And I know you keep getting pushed on this, but I think this is where we're getting tripped up, because I understand where you're coming from, that this wasn't litigated below. But I guess the question is, do you believe that her opinions were beyond the scope of the report?
No, ma'am, I do not.
Okay.
Okay,
so
counsel,
sufficient.
I'm sorry. I'm looking through the transcript itself, and at trial, counsel said that she was objecting to her being classified as an expert because you're required to provide a report outlining what her testimony is expected to be 21 days prior to trial. And she is objecting because she's being qualified as an expert, and the report doesn't say what she's going to be testifying to. So that she did object to that.
Well, she in a later sentence said that she expected all of this testimony and that she certainly expected her to be testifying as to these things. And her statement that the report must contain a specific summary, a detailed specific summary of what she is going to testify to, is a misreading of Criminal Rule 16K, which is in the alternative. The report, according to satisfy 16K and to allow the testimony, the report has to have the findings or the testimony or the analysis or the opinions that are being offered. Certainly based on, like Hall and some of the other cases, we would say, and Davis, the case that I mentioned earlier, if the report, if the witness wants to testify as to opinions that were not contained in the report, we believe that that would be improper. However, that's not the case here, and there's been no allegation that she testified to opinions or offered expert opinions that weren't contained in the report. So while trial counsel did say, I don't think I've gotten a report because it doesn't have the testimony, she then in the next sentence says, I expected all of this testimony. So I'm not sure what exactly.
The report just doesn't explain how she got to the opinion. I mean, she testifies about the type of drug and the weight, but right? So that's your argument is, it just doesn't have how she got there, which you're saying doesn't need to be in a Rule 16K report.
And not for I don't believe for the report to satisfy 16K and to allow the person to testify. If those issues wanted to be challenged, the challenge how she arrived at that, then that issue needed to have been litigated below. It was not. And therefore, I believe that the report does satisfy 16K and did not preclude her testimony. In addition, I would also say that it's a misstatement that 16K then precludes the witness from testifying at all. It would only be expert opinions and expert testimony that would then have to be struck from the record. And there was no objection to the testimony that was provided in the record on this case. If I can jump back to the motion to suppress, and I'll also take a real quick moment to address the sentencing issue at the very end. In looking at this case this morning, I discovered that Mr. Thompson has been judicially released. So I believe that sentencing issue has been rendered moot. Judge Jenkins, I believe it was on August 6th, granted a motion for judicial release. And so any issue as to the sentencing, the consecutive nature or the imposition of the sentence, I believe has been rendered moot by that. I apologize for not having time to update the court with that information, but it was this morning. As to the motion to suppress, and I guarantee I'm running out of time, so I'll try and
you've got a few minutes. You're fine.
Okay. I'll try and hit the highlights. In terms of inadvertence, the case law on inadvertence and the plain view exception and everything like that deals with cases where officers have, they say that it might be appropriate in issues where they've manipulated circumstances to create an exigent circumstance to then allow them to enter a building or to do something like that. And that's what those cases are dealing with, not something where, yeah, I saw some furtive movement. I thought it might have been a gun. I thought it might be drugs, but there's something there. And it's not clear that it was just drugs, as the officer can be heard on the video informing the other officers that there's something there. Be careful. Keep an eye on that center console. I think that that's about officer safety and that's what's going on there. In terms of, I believe there was talk about when the clock should start running. One, the body cam shows the officer, the car still in motion and the car being put in park. So speculation that they had been sitting there for a while before he got around to finally turning on his body cam is contradicted by the video itself. Two, I believe, Judge Bergeron, you had mentioned the 6 minutes. And that is from the time that Officer Smith walks away after having delivered the ticket and says, hold tight here. It's 6 minutes before the other officer arrives. I would say that that's a decent place to start, but and this will get somewhat into speculation a little bit. They still would have at that point, they still have a vehicle that is illegally parked with two uninsured and with two unlicensed drivers. there still would have needed to have been some time to find out who this other individual was, this friend that was there, and to engage in.
Well, but I guess my question is, like, at some point it becomes too long. I mean, we can't let the officers play four corners offense forever with someone that they pulled over. So how would you draw that line?
Absolutely, Your Honor. And I think that the 6 minutes, I believe that there is no question that the stop was extended and that there needed to have been reasonable articulable suspicion based on the totality of the facts and viewed in light of the officer's experience and training. And that's what the case law says. Cannot be read in isolation. As Judge Bach was referring to, while each individual issue might not have satisfied reasonable articulable suspicion on its own, the totality of them, the furtive movements, which the officer testified, because the windows were rolled down, he could see as he approached the vehicle. While that's not captured on the body cam, it doesn't have to be captured on the body cam. The eyes
Counsel, do you agree with Ms. Geiske that the state abandoned the high crime area as a factor?
No, ma'am, I do not agree with that. I don't think that is an accurate statement at all. That the high crime area has always been something, and while it might not have a tremendous amount of weight, it is not just in this case, not just a high crime area, but it's specifically a high drug area with an insufficient explanation as to what they were doing there. The officer can be heard on the video telling the other officer, yeah, they said they just kind of went over there. That's a place where we got a lot of drug trafficking. And he said they just kind of got out, but that doesn't make any sense to me. So it's not just the being in a high drug area, it's being out of the vehicle in a high drug area, coming from there with no adequate explanation. This is whether we agree with that or not. It's the question as to whether or not it was reasonable for Officer Smith, based on his training and the facts available to him at the time, the totality of those facts, whether it was reasonable for him to think, and it's not probable cause, it's reasonable suspicion to continue the detention for, even if we go with the extra 6 minutes, for the 6 minutes. So we have the furtive movements, we've got the high drug area, we have his prior interaction with him, which is a factor that can be considered and go into the officer's concern, and probably one of the concerns for why he thought there might be a gun, because he had been at that same location with the same individual and there had been a weapon involved in that prior incident. We've got the nervousness, the attempting to conceal the area. All of these things factor into whether or not the officer had reasonable articulable suspicion to believe that there was criminal activity afoot, and we would suggest that it does. I know I talked really fast at the last portion because I was trying to get it all in. Are there any questions, or are there any issues that I have not addressed that the court would like me to address?
Any questions from the panel? All right, you got it with 30 seconds to spare, Mr. Donovan.
Thank you, sir.
All right, thank you for your argument. Ms. Gieske, you have 2 minutes.
Thank you, Your Honor. To clarify my argument on the high crime area, that it's not that they abandoned it. It is that it didn't come up until trial itself. And I just looked back at my notes really quick and did a search for high crime and didn't see that come up until trial. Same with one reference to a gun appears, and that was at trial. So again, we have to just confine the motion to suppress assignment of error to the suppression hearing. Regarding, I want to go back to, I think the most important issue here, though, is the criminal 16K one. Excuse me. And, you know, Judge Bach, you hit the nail on the head. You read exactly the transcript, page 322, that I was going to go to, where counsel objected, saying she didn't, about the line about the testimony. And, you know, it comes down to what, in order to invoke the waiver doctrine, what more does defense counsel have to do? You know, waiver means the trial court, without the known relinquishment, but as far as forfeiture, that trial court did not get the opportunity to weigh in, and they most certainly did. You know, in the heat of trial.
But even if it's preserved, it sounds like you're arguing that the methodology, how she gets to the opinion, has to be in this report, not just the opinion, because she didn't offer any opinions beyond the report, right?
The opinion is the one, the first prong of the criminal 16K just says that they have to outline, and really, I guess the objection is that she went beyond, yes. And you put it, Judge Bergeron, I think, putting it in terms of methodology is the best way to say that that is not what was brought to counsel's attention in any report beforehand, yes. So that would be the biggest.
But the ultimate opinions that she offered were the type of drug and the weight of the drugs, right?
It was, and we didn't get into it and we won't, but under the manifest weight argument, I still to this day think that trying to cross-reference what was taken from where, and then looking at the numbers attributed to that on the report is very confusing and hard to follow.
Yeah, but what I'm saying is that she didn't offer an opinion beyond the type of drugs and the weight of the drugs, right?
Correct, but she did, I guess it would go more to the second prong of qualifications, added a lot more at trial than none of it was present in that. But the methodology.
The issue that we need to look at is the fact that her qualifications weren't included.
And the methodology. I would say the methodology still goes more to the testimony and findings prong. That's the first prong of 16K. And then the qualifications is where she went beyond at trial, saying what she had done for training and education purposes.
Oh, but if I want to understand your argument, but like if I say I went to law school on this date and got this degree, and I went to college on this date and got this degree in my report, but then I'm on the stand and I'm like, oh yeah, I published a couple articles and I went to some CLEs and that's my experience. Like, are we going to say like the expert can't kind of give more details on their background?
It's going to have to be a case-by-case determination, but just like I believe it was in State versus Rosemond, where there was a bullet trajectory report by Detective Landisberg, I want to say it was, and it was just a drawing. And I think, hopefully I'm not mixing up cases, but he had said that he went to one class, one class, and no report was provided. And it does come down to if you add. It can affect your qualifications, where certain training can make you more likely to be a proficient expert. It depends on what it is. So counsel has to be able to know what that is. And what I wanted to emphasize is, when you're placing these the burdens for preservation on defense counsel, you can't. Not everyone can be Shakespeare in the heat of trial. We would argue that she presented enough for the court to, and even if she didn't word it perfectly, and even she said, "I'm just challenging her expert status." She did say, "I have no report," and I would like to directly quote the staff note to 16K, which the High Supreme Court drafts the rules.
And Ms. Giese, you're past your time. We
okay.
Peppered you with questions, so I gave you a little
okay.
time.
Thank you. We would just ask the court reverse and remand for a new trial. Thank you.
Okay. Thank you both for your arguments. We appreciate them.
Okay.
The case will be submitted, and we'll issue a timely written decision.
Thank you, Your Honor.
Okay, good morning, counsel. The next case on our docket and the last case to be argued today is State versus Porter. Good morning, Ms. Wood and Mr. Sinclair. Mr. Sinclair, how much time would you like for a rebuttal?
2 minutes, thank you.
2 minutes. All right, you may proceed when you're ready.
Good morning, may it please the court. This case involves two sisters who got into a fist fight after a day of shopping. They both went shopping in their car together, and the sisters did have a lot of verbal disagreement towards the end of the shopping trip. And they got into a physical fight when they exited the car at the conclusion of this shopping trip. During the trial on direct, the prosecutor presented one witness. That witness was Ms. Porter. I'll refer to Ms. Porter as the victim, even though at the time I believe they had the same last name, and Ms. Hill as the defendant. Ms. Porter stated that she was punched in the face by my client, and that's how the fight started. At the conclusion of direct and the conclusion of the state's testimony, the cross-examination by the defense attorney started, and the victim stated after questioning that she acknowledged that there was a video which occurred, police body worn camera, a video that existed in which police officers went up to the apartment and spoke with the alleged victim right after the incident. And during the trial, the alleged victim, Ms. Porter, stated, "I now can see, it's 4 months later, my memory's not good, but now I can see that based on that video, it is apparently true that I did shove my sister twice at the beginning of this physical confrontation." And then Ms. Porter stated, "I can't recall none of it now. It's 4 months later, it's December now. I do acknowledge what's stated on the video, and I don't have any memory to state otherwise." At this point in time, the burden had shifted to the prosecution on the self-defense issue. The statute says that any—
So you're saying that the act of shoving in and of itself triggers the self-defense?
that is correct. The statute says that evidence that tends to support self-defense, force used in self-defense, is the trigger. So the two shoves are, by the statute, evidence that tends to support self-defense. The state presented no other testimony, no officers testified, and at the end of the state's case, the defense attorney made a proper Rule 29 motion. I think the Rule 29 motion was correct on two fronts. On the fact that we had one witness testifying. She acknowledged her memory was not good on how this physical fight, which occurred between the two sisters, started, or actually what occurred during the fight. And as a appellee makes mentioning many times in her brief, there's a lot of issue about what Ms. Porter is holding on to. Her hands are full. She's holding a phone. She's holding groceries. She had no business getting into a physical fight with the appellant. But the video states that Ms. Porter, and she doesn't dispute it, that she shoved the appellant twice. So the two shoves seem to discredit this whole thing about appellee stating that her hands are full. But at the conclusion of the state's case, the Rule 29 was proper because the burden did shift. It did shift to the prosecution. And the prosecution did nothing at all to present an argument about the burden shift. The prosecution did nothing to dispute self-defense. The judge asked the parties, "What do you think about these two shoves? How do you weigh these two shoves?" And the prosecutor's answer, I don't think it was difficult for me to understand the prosecutor's answer, but he didn't dispute the issue before the court, and that is the burden shifted. And also the state's case was much, much discredited based on a single witness who stated that her memory was no longer good.
But Mr. Sinclair, Ms. Porter, the victim in this case, or I'm sorry, Ms. Hill, Ms. Porter also testified that her sister grabbed her by the neck, shoved her to the ground, tried to kick her. And there was more than just, "I don't remember." I mean, she testified to several different acts.
Ms. Hill, so Ms. Hill's the appellant. Is that right?
No, the victim.
Why don't we just use victim and defendant?
idea.
Because this is getting confusing.
Yes. So the victim in this case testified that her sister punched her, grabbed her by the neck, threw her to the ground, and then tried to kick her in the stomach, and she was pregnant. And also, I mean, the pictures definitely showed injuries. So, I mean, to say that, she doesn't remember anything is, I think, a little bit misleading.
Well, I don't think anyone disputes, and I don't think there was any memory issues about injuries. So I think all parties, all counsel agreed that the two sisters both had physical injuries. They both had physical injuries from this physical altercation. So I don't dispute that. I just dispute the testimony about how the fight started. But I think both sisters agreed that they both caused. Well, Actually, I don't know. There are injuries. There are injuries to both parties at the conclusion. And of course, injuries can be caused with intent to cause physical harm, or they can be caused by defending yourself. Of course, you can also be injured when you're being attacked by somebody due to all the physical altercation. Sorry if I didn't answer that question. That's all I had, Your Honor.
Okay, thank you.
Thank you.
Ms. Wood, we'll hear from the city.
Great. Thank you, Your Honors. Good morning, Your Honors and opposing counsel. May it please the court. This court should affirm the defendant's conviction for domestic violence for the following 3 reasons. First, the trial court properly denied the defendant's motion for acquittal under Rule 29. The defendant's conviction is supported by sufficient evidence and does not go against the manifest weight of the evidence that was presented in this case. I'm going to start on the Rule 29 motion. As this court is aware, when a trial court is looking at a Rule 29 motion, they're reviewing all of the evidence that has been presented on the state's case in the light most favorable to the prosecution, and they're looking to determine whether any rational trier of fact could have found that all of the elements were proven beyond a reasonable doubt. In this case, you had testimony from the victim that she and the defendant are sisters, that they lived together for a period of time when they were younger, that the defendant attacked her first, struck her in the face, grabbed her by the neck, threw her on the ground, and there were photos of the injuries that she sustained from this attack. So just as a base prima facie case, the state met all of the elements necessary to prove self-defense.
Well, what about the testimony regarding the shove, or the 2 shoves?
And this is where we get into the defendant's self-defense issue here. So under the amended self-defense statute, there is that tends to support language, any evidence that tends to support that the defendant acted in self-defense. That tends to support language, as this court held in Williams, is not as simple as long as somebody said they shoved me, I get to argue self-defense. There are 3 elements of self-defense that the defendant has to raise reasonable doubt for. So they have to raise reasonable doubt first that the defendant was not at fault in causing the situation that led to their use of force. Second, they have to raise reasonable doubt that their belief that their use of force was necessary to prevent imminent harm was reasonable. They also have to raise reasonable doubt that the force that they used was, we'll call it proportionate to any threat of harm that they faced from the victim in this case. Those 3 things have to have reasonable doubt before the burden shifts to the state to disprove self-defense beyond a reasonable doubt. State is arguing that that burden of production, the defense's burden of production, was not necessarily met here. Specifically as to the second element. So if you look at the Williams case, that was a case where prosecuting witness and the defendant both testified that the victim in that case went up to the defendant, snatched his headphones out of his ears, and then went and sat down. After she took the headphones, the defendant hit her. He claimed that he thought that she was going to hurt him, so he struck her in self-defense because she physically approached him and took something that was on his person. This court said, no, you've failed to meet your burden of production as to the second element of self-defense, which is the belief that your use of force is reasonable, because the victim at that point had moved away, had sat down, had not caused any further injury. There was no evidence that she was going to harm him such that the defendant's belief would be reasonable.
So even if they produced evidence on the first piece of it, who caused the issue, you're saying still they didn't meet their burden as to the second prong, and therefore the burden never shifted to the state.
Correct, because there has to be reasonable doubt raised as to all 3. Now, whether or not you believe the defendant's version of events that the victim shoved her first, again, we would dispute that and say that that's not credible, but I'll get to that in the manifest weight argument a little later on. But yes, the fact that the victim was on the opposite side of the vehicle, there was a car in between them, that she had her hands full, she had a phone, she and the defendant stated that she was talking on the phone, she had her keys, she had a full load of groceries that she was handling by herself, and the car door was shut. There was no reason for the defendant to stick around, one, and instead what the defendant did was came around the vehicle, approached the victim in an aggressive manner, and at that point hit the victim. Even if you take, and this will go into burden shifting, just to address for the sake of argument, you find that the testimony about the two shoves is evidence that tends to support. And you
Well,
find
we have to look at it in the light most favorable to the defendant in that regard, right?
correct.
Okay.
Correct. So it is in the light most favorable to the defendant. So then necessarily you have to address, well, if you find that, and the burden flips over to the state. The burden for the state is different in that, yes, we have to disprove self-defense beyond a reasonable doubt, but it's only as to one of those three elements of self-defense. If you disprove beyond a reasonable doubt any one of those three elements, you have overcome any burden of production that the defense has met. So in this case, you're looking at state proved beyond a reasonable doubt that the defendant was at fault in creating the situation that led to her use of force. She had already dropped the victim off at her home. The defendant didn't reside there. Victim was out of the car with all of her items. Defendant wasn't helping her move them. Victim had closed the car door. There was some discrepancy in the testimony as to whether it was a closed door or a slammed door. But the closing of that door was what prompted the defendant to come around the car and then attack the victim, excuse me. So she had ample opportunity to leave the situation, which is what she testified she wanted to do in the first place, was get out of there. But instead, she approaches the victim in that aggressive manner, and then this altercation begins. Moving on to the second element, even if assuming you believe the testimony that the victim shoved the defendant first.
Wasn't that the victim's testimony though?
It was the testimony it was the evidence that was presented on the body-worn camera.
That the victims told the officers.
That the victim,
she told the officers that she shoved her sister first.
Yes. Her testimony in court was that I don't remember telling the officers that. And her explanation for her speaking in the video was she clarified, she said in her testimony, do you see how upset I am there? I'm crying. I'm shaken. She's heavily pregnant at that time and worried about her child. So she didn't remember. Her testimony that I don't recall was about what she told the officers, not about the altercation. She remembered the altercation, and you, Your Honor, pointed that out. She remembered and testified as to her memory of the altercation. So for the sake of argument, assuming you believe because of her testimony, because of the video where she told the officers, whatever the case may be, if you believe that she pushed the defendant first, then you get to this second element of whether the defendant's belief that their use of force was reasonable to prevent imminent harm. And again, we're kind of looping back to the victim's got her hands full. She's talking on the phone to somebody else at the time that this happens. And she's 7 months pregnant at the time. And she testified over and over again, I was worried about my baby. The whole argument, verbal argument, even started because of this defendant's driving made her worry about the fact that she was pregnant and didn't feel safe in the car. So her starting a physical altercation with her sister when she has things to do and places to be, she has separated herself from the argument anyway by being on the opposite side of the car when the defendant comes around. So there's no reasonable belief that the defendant is in fear of imminent harm there. Most importantly is this third element as to whether the use of force was proportionate to any threat of force that she faced. And the court acknowledged this, the trial court acknowledged this when they were rendering their sentence, or when they were rendering their verdict, excuse me. The victim in this case sustained injuries that were presented in the state's exhibits that required hospitalization. She was hit in the face. She was grabbed by the neck. She was thrown to the ground. The defendant continued trying to kick her after passersby tried to separate them. She had to go to the hospital because of the nature of her injuries. The defendant, by comparison, had some minor scratches to the face, did not have to be hospitalized. The court acknowledged that. In rendering its verdict, it was going through and saying, like, even, this court's duty is to evaluate the testimony of the witnesses, and even if the defendant used force in self-defense, to determine whether that use of force was reasonable, the court finds that it was not, and then found her guilty anyway. So as to each of those three elements of self-defense, the state did disprove beyond a reasonable doubt that the defendant acted in self-defense, and therefore the motion for acquittal under Rule 29 was properly denied. Moving on to, I'm going to kind of gloss over the sufficiency argument because a lot of that is a rehash of what's discussed for the Rule 29 argument. So moving on to what I think, pardon the pun, should be afforded more weight is this manifest weight argument. So the credibility of the witnesses is the defendant's major contestation here to the verdict. The credibility of the prosecuting witness, given the body-worn camera video that contradicted her testimony at trial. First of all, the trial court is the court that determines credibility of the witnesses. They are the best seat in the house to see the witness's demeanor, to compare their testimony to, testimony that is offered by the defendant, to look at any exhibits that are offered and determine if everything matches up. So trial court is in the best place to do that. Even those inconsistencies in the victim's testimony are not fatal to her credibility as a witness. This court in 2019 decided a case, it's State versus Baxter. It's a sort of a similar situation, another DV case. The defendant shoved the victim in that case into I think it was a display table in a store, causing injury. There was body-worn camera that was presented in cross-examination as impeachment evidence, where the victim told the officers there were details of the fight that she didn't include in her testimony. Like the defendant had struck her in the face. I think there were some other details that were explicitly excluded from her testimony. The court found that despite that victim's inconsistencies, despite the fact that her testimony did not line up exactly with what she told the officers, her credibility, her demeanor at trial, the other evidence that was presented was properly reviewed by the trial court, and was enough weight. There was enough weight to that evidence to support the guilty finding. Same situation in this case. The trial court heard the testimony of the prosecuting witness and could compare it to the testimony of the defendant because she did decide to testify in this case. The trial court saw and heard the statements that the victim made to the police on the body-worn camera and could compare that to State's Exhibits 1 through 3, which were the injuries that she sustained in this fight and the testimony that she had to be hospitalized for those injuries. Could take all of that and compare it to the defense's exhibits of the photographs of the injuries to the defendant. The court had every opportunity to review every piece of evidence that was offered, to evaluate all the credibility of both the victim and the defendant, and made a determination based on all of that evidence that the defendant did not reasonably act in self-defense, that the inconsistencies in the victim's testimony were not fatal to her credibility, and found the defendant guilty. There's nothing in the evidence that shows that the trial court clearly lost its way in reaching that determination. So we would ask that you affirm that guilty finding.
We can't really even analyze this under a sufficiency, right? I mean, as far as whether or not the state proved or disproved self-defense beyond a reasonable doubt, that what you're saying is really it's a manifest weight review, not a sufficiency review.
The Rule 29 motion is, there's case law about it, excuse me for not having it in front of me, but the determination of whether there was sufficient evidence under Rule 29, that is a sufficiency argument.
But does that just go to whether there was sufficient evidence of domestic violence? Or do we also look at sufficient evidence of disproving self-defense?
Both together, and I apologize for interrupting. I think I'm on a lag here. First, the state has to obviously meet, it can't go anywhere if it doesn't meet the essential elements of the offense. So you're looking at sufficiency for that. Once the defense raises evidence that tends to support the self-defense argument, that burden shift also necessarily requires sufficient evidence to disprove self-defense. So you have to do both.
Counsel, there is case law out of the 10th district saying that that's not the case. You can't, on a self-defense issue, even though the statute changes the burden of proof, it doesn't change the burden of production.
Correct. So yeah, and that's what I was, let me try to explain it a little clearly. So the state's first goal in its case in chief is to present sufficient evidence to meet each of the essential elements, in this case of domestic violence. If those are met, because you'll get Rule 29 if you don't meet those essential elements, if there's not enough there just because you didn't prove those elements.
But is self-defense now an element of the offense?
No, self-defense is not an element. So you prove the essential elements of domestic violence. The defense then argues there was evidence presented in the state's case in chief. Here, it was in cross-examination with that video. There's evidence that tends to support self-defense. If the court finds that to be true, there is evidence that tends to support, they have satisfied their burden of production, which then triggers the state's burden to disprove beyond a reasonable doubt that the defendant, did not act in self-defense. They also have to do that. There has to be sufficient evidence, because it's that beyond a reasonable doubt standard. There has to be sufficient evidence presented by the state to make that argument that disproves self-defense. Manifest weight.
And Ms. Wood, you are at your time now.
Okay.
Thank you for your arguments.
Thank you.
Mr. Sinclair, rebuttal.
There we go. Sorry, thank you. I think this case is not a case of where we are deferring to the trial court on weighing the credibility of witnesses in the courtroom. This case is much different than that. This is a case of, and I don't even know that I would say that I'm discrediting the victim's credibility. I think her memory is so deficient that the evidence before the court it does not support a conviction, and also doesn't support the issue of self-defense and the burden. The victim herself stated how she thought this whole fight happened, and she states this 4 months after the incident. And then in trial, when appellee states that, well, someone's presented evidence that tends to support. This is the victim who presents it. The victim acknowledges that there's 2 shoves that tend to support self-defense. The issue isn't about the trial court weighing credibility. This is an issue of how does the court find defendant guilty beyond a reasonable doubt? The highest burden that we have, the highest burden. And he's doing it when he has one witness in front of him who he just finds cannot recall how this fight went down.
But you're concentrating on who started it. I mean, there are additional elements, right? And I think the state's arguing that the force used was unreasonable. So there's more than just who started the fight involved here, right?
I don't know that any of us know what force happened at what point in time. The only evidence that we know is really clear before the court is there are 2 shoves by one party against the other one. And then we know that there's injuries at the conclusion of this physical fight. And we all know that if you get assaulted on the street and you're defending yourself, it's a good chance there's injuries on your assailant, there's injuries on you. So the injuries, I don't know how those go one way or the other. How, if the issue is, who's assailing who and what's the issue of self-defense. But I think that this trial court didn't have enough to meet the burden of reasonable doubt when the victim herself acknowledges her memory is not as good as she thought it would be. Actually, it's extremely deficient because she's stating that she remembers exactly how it happened, and it didn't happen that way. And I also think there's plenty of evidence before the court that the appellant got out of the car to close the door. She did not get out of the car to go assault her sister. She got out of the car to close the door because her sister did not do so, the victim. And for that reason, I think that the case should be overturned because there's not the reasonable doubt is not met, and also the issue of self-defense. Thank you.
Thank you both for your arguments this morning. We greatly appreciate it. The case will be submitted and we'll issue a timely written decision. And wish you both a great day.
Thank you.